thank you very much for attending this webinar. My name is James Wood. I'm Head of International Content at the Legal 500. So as you'll have seen from the emails we've been sending you, that the webinar is titled Guiding Your Business Through a Time of Crisis. And Korea obviously has made some very interesting attempts to stem the COVID-19 pandemic, some very successful attempts as well, but obviously there are still many challenges for businesses operating in that country, and a great deal of interest from businesses and lawyers outside Korea, which is why we're broadcasting in English today. So apologies to those of you who now have to sit through a presentation in English, but the idea is ultimately that we will share this video with people who are interested in the Korean market in the US, in the UK, in Europe. So we thought English was the best language. And I'm delighted to say we will be hearing from lawyers of Jipyong law firm today. Jipyong, as I'm sure many of you know, is celebrating its 20-year anniversary, one of the preeminent and leading firms in the Korean markets, and a great pleasure for us to hear from them. Also a great pleasure and a big thank you to Jong Myung Park, JM, as he's known, who is General Counsel of Delivery Hero in Korea. JM has kindly agreed to share his perspectives as GC, so we'll be hearing from him later in the presentation. Sincere thanks, JM, for giving us a GC perspective on this. Okay, well, that's all from me. I will pass over now to Jin-hee Kim of Jipyong, who will introduce the team. I'll just say finally, we do want to make this as interactive as possible, so if any of you have any questions throughout the presentation, please do use either the chat or the Q&A function on Zoom to submit your questions. We'll try to deal with as many of them as possible. Okay, Ginny, please.
It's a pleasure to be joining the webinar today. I am especially pleased to be introducing my colleagues because we rarely get to actually participate together in webinars like this. So the six of us have come together to address a variety of topics that concern COVID in Korea. And in the order of the speakers, maybe you could just wave as I introduce you. The first speaker will be Bernard Ham. Bernard comes from a really variety of past experiences. He's actually practiced litigation in the States. He has served in-house for many years. He doesn't look it, but he comes with considerable experience in IP, IT industry. He's currently spearheading Jipyong's bio and pharmaceutical industry practice. Next to him is Hoon Lee. Hoon is in our corporate department. His specialty area is construction and energy industry. And John, followed by John Rowe. John has very interesting clients all over the world and very unique practice as well. So it'd be very interesting to hear from him. Next to him is Jane Sohn. Hi. Jane is a UK lawyer, our cherished UK lawyer. She handles a variety of corporate matters that really relate to UK law in particular, but other laws elsewhere too, because she's had practices in Dubai, and she comes with quite really varied specialty areas, and it will be interesting to hear from her about her advisory role in labor issues. And followed by Jane is going to be my colleague Jenny, sitting next to me. She's our finance specialist at Jipyong. She's a Canadian lawyer, also a very rare expert in Korea, because we rarely have Canadian practitioners practicing in Korea. And I had the dispute resolution practice at Jipyong. It's a pleasure to be here for all of us, and glad to meet you through webinar. So starting with Bernard, let's start discussing.
Great. Thank you. Thank you for that introduction, Jeannie. Korea reported its first COVID-19 case on January 20th. And for about a month afterwards, Korea experienced a significant jump in the number of cases, similar to what most other countries are going through. But as you can see in the headlines in this first slide, Korea did something remarkable. It began to gain control over the spread of this disease. Today, I'd like to introduce to some of the legal developments that have taken place since the beginning of this pandemic. and how they have impacted the government's management of the pandemic in Korea. Shortly after the first case on January 20th, the Korean government quickly got into a crisis management mode to combat this disease. The government determined that the existing infectious disease and medical services laws needed to be strengthened, which is what they did. The so-called trio of COVID-19 amendments were passed, which gave the Korean government the tools it needed to effectively manage resources and the means to enforce behavioral change in the population. The trio of COVID-19 laws that have been amended are the Quarantine Act, Medical Services Act, and the Infectious Disease Control and the Prevention Act, the three laws that you see in this slide. Now, the purpose of the amendment to the Infectious Disease Control and the Prevention Act was to strengthen the penalty associated with violation or non-compliance. The government has always had the power to isolate or quarantine suspected patients in infections, but previously the only penalty that was available to the government was a fine, monetary fine of a small amount. But now, the government can throw you in jail, you can be imprisoned, and you can be fined up to nearly $10,000 US. And the ability to implement isolation and quarantine measures has been key to the government's containment activities. I have some numbers that I can share with you on the enforcement area in this. As of June 15th, last week, there have been 830 individuals found to have violated self-isolation rules. And of the 830, 336 were prosecuted, 6 of them thrown into jail. And investigation is ongoing with respect to 490 individuals. It's reported locally that the amended law has real teeth in forcing compliance in the general population. And to ensure that the government has the resources to manage infections and pandemics, the new law has given the government power to ban medicines and medical products from being exported. And the penalty that was provided in the law for violation is quite hefty. You can be imprisoned up to 5 years, or subject to a fine of $50,000. This law, however, has not been invoked by the Korean government yet. Now, to have an accurate accounting of the infectious cases in medical facilities, the Medical Services Act was amended to make it easier for anyone in medical facilities, whether you're there as a patient or as an employee or as a contractor, to report COVID-19 cases to the authorities, so that without the fear of being for retribution from the facilities. The Quarantine Act was amended to allow the government to prohibit foreigners from entering Korea, specifically because of the infections. Those who are infected, or those who have been exposed to infection, or those who have traveled through countries that are experiencing heavy infections can be banned from entering Korea. Now, early on in the process, in the pandemic, the Korean government identified that wearing masks and frequent cleaning of hands would be critical to controlling the infection. Now, through regulatory notices, the government therefore identified masks and hand sanitizers as products that should be subject to government control, whether the export is prohibited or whether the production and distribution issues are controlled. Now, all mask manufacturers are required to sell 60% of their daily production to the government, and no more than 10% of their production can be exported. and they have to report their production, distribution, and inventory numbers to the government during the pandemic. Now, another important development that has been brought about because of the pandemic is the Korean government's willingness to experiment with what's called telemedicine. Under Korean law, it's remote medical treatment, but for purposes of this discussion, I'll refer it to as telemedicine. Under the current Korean law, the only type of remote provision of medical services that's allowed is between a physician and another physician. That is, a physician, let's say, located in a major city, advising a physician located in a rural area for the patient located in that rural area, which means the remote provision of medical services using telephone to a patient is currently prohibited under Korean law. However, to shield medical facilities from COVID-19 spread, the Korean government has decided to do an experiment in telemedicine. Temporarily, the government has allowed telemedicine, including the issuance of prescription drugs. Of course, there are parameters around this. It must be directly with the patient. That is, the physician needs to speak directly to the patient. The physician can send a prescription to a pharmacy designated by the patient, and the patient needs to work on an arrangement with the pharmacist for the delivery of the drugs. So there are parameters around how this needs to be conducted. The Korean government has also allowed the patient's direct family members to visit the patient's physician for the purpose of receiving a prescription. The prescription must obviously be for the same disease, and the physician must certify that it is safe to dispense prescription this way. Now, this experiment is ongoing, but we have some preliminary data from the government. From February 24th to May 10th, there have been 262,000 cases of telemedicine. And after a survey of nearly 1,000 patients, the government found that nearly 90%, 80% to be specific, of patients were satisfied with this experience. And as you can see in the pie chart on the right, nearly half of all telemedicine cases were done at small-scale clinics. Now, what does this mean for telemedicine in the future? Korean Medical Association, which is the physician association in Korea, is quite opposed to it. It has expressed concerns that small-scale clinics would not benefit from the adoption of telemedicine, and there would be a high possibility of misdiagnosis. Well, the empirical data that I just shared with you in the previous slide seem to suggest otherwise, and so far we have not heard of a news report of a misdiagnosis. But nevertheless, the association is so opposed to it that some weeks ago it issued a statement to its members that to stop practicing telemedicine. A government official shortly thereafter came out and said that telemedicine in Korea is temporary, and there is no plan to make telemedicine permanent. But to make matters interesting, President Moon Jae-in recently remarked during a cabinet meeting that the development of telemedicine should be looked into. So the future of telemedicine is up in the air in Korea, but because of this pandemic, Korea is experimenting with it, and we'll just have to see how this is going to play out into the future. Now, Korea is still experiencing pockets of outbreaks. A month ago, we had an outbreak centered around a popular nightclub, but that was quickly contained. And looking at what's happened in the last 4 to 5 months, what's clear to me, it seems to me, that the Korean government has some legal means and the will to effect behavioral change in the population, and is also willing to experiment with new ideas such as telemedicine for the purpose of defeating this pandemic. Thank you for your time, and I'm happy to answer any questions you may have. Thank you. Yes, please.
Hello, it's very nice to meet you virtually. My topic deals with COVID-19 as a force majeure event, which is topic widely discussed these days among many businesses and companies. So I understand that many companies are already planning on making operating businesses on the basis that the COVID-19 could be regarded as a force majeure event. So I will not go into many details regarding force majeure, but briefly touching upon the elements constituting a force majeure event, and briefly discuss Korean laws, how Korean laws treat force majeure, and in the process, I'll try to give you practical feedback advice which may be helpful to you in terms of dealing with the COVID-19 as a force majeure event. My first slide it gives a definition of force majeure, an exceptional event occurring after execution of contract, which is beyond a party's control, and which such party could not reasonably have provided against. And if you look at this definition, there are two key elements. One is you could not have control the event to prevent from occurring, which is called the uncontrollability element. And the other key element would be there was nothing you could have done more to avoid the outcome, which is called the unavoidability element. The effect of a force majeure would be, as you know, normally to suspend the affected party's performance for the duration of the event. And national laws, whether the common law jurisdictions, which is based on strict liability regimes, they recognize the force majeure. You heard impossibility doctrine, fostering the corpus doctrine. The common law countries recognize force majeure, and of course the civil law countries, which is based on liability on fault, they recognize force majeure, and the contracts, including international contract, they mostly include force majeure clause. So just to give you my personal opinion at this point, COVID-19 is widely regarded as a force majeure event, but obtaining actual relief from that may vary from case to case or from contract to contract. So my next slide presents briefly about the how the Korean law treat force majeure. As I told you, Korea is a civil law country, so Korean civil laws impose liability based on fault, which means that if you fail perform an obligation, such failure is presumed to be based on your fault. So you have to prove that the failure to perform was due to something other than your own fault, such as force majeure event or to the other party's act. So there is a basis. There is a basis under Korean laws that recognize force majeure. But please note that Korean courts are very strict in interpreting recognizing an event as a force majeure event. Under one Supreme Court ruling, Supreme Court stated that the force majeure event is occurrence of an event which was beyond your control and the results of which you could not have prevented or provided against the event. So it's very similar to the definition we just discussed earlier. And just give you one quote example. This is also a Supreme Court case. heavy volume of downpour that, in a short period of time, that created chaotic road conditions. Could be considered, an act of God, but Supreme Court said that it wasn't enough to be a force majeure event. If the party claiming relief could have taken additional measures to provide against, the event. Here in this case, it was, the party claiming relief was Korea Expressway Corporation, claiming, arguing that the heavy downpour was, a force majeure event that would lead to, relief from, performance. But the court stated that, the Korea Expressway Corporation, could have done additional measures to make, the roads safer. So, but they denied the, claim of the Korea Expressway Corporation. So I just told you that the Korea laws recognize force majeure. So let's say that there's a contract. There's a contract which does not have a force majeure clause, but governing law is Korean law. Then in that case, even though there's no force majeure clause to rely upon, you can still rely upon governing law, which recognizes force majeure event. Just quickly to give you two examples. A Korean supplier claiming exemption from performance due to one of the suppliers not being able to provide parts because of COVID-19. This claim may likely fairly because as Korean courts may say that supplier could have kept inventories at sufficient levels or could have procured parts from alternative sources to provide against exceptional events. So again, emphasizing that what party has done to provide against the event is very key element. Another example, which in this case very successful, Korean supplier having only one source of supply, part supply from say coming from China, but the Chinese suppliers not being able to export parts because the Chinese government shutting the border. In that case, the Korean court may say that it is indeed a force majeure event and grant relief. So, but my next slide. Regardless of national laws, it is always good good to have a very elaborate and detailed force majeure clause on the contract. And on this slide I gave you a very this is from actually FIDIC contract. This has very good definition of the force majeure clause, and normally this kind of clause would list of events, examples of force majeure events, including terrorism, earthquake, pandemic. Some clauses do not have pandemic, but I would recommend, of course, to put down pandemic as one of the listed force majeure events. But still, we have to, even if the pandemic is there, we still have to satisfy the elements, that constitute force majeure event. That is required under the contract or under the governing law. So my point here is that if any given contract has designed very elaborate, detailed force majeure provisions, we can pretty much disregard the governing law. Okay, my next slide provides things to be done in order to claim relief based on COVID-19 as a force majeure. Sending notices is very important. It's always important to be compliant with the stipulated time periods under the contract. If you do not send notices or delay, it gives the other party excuse to claim contractual breach on your part, and also deprive the other party opportunities to take mitigation measures upon receiving such notices. And taking mitigation measures, it's always basic obligation of the party claiming exemption from contract performance, and providing on details, providing giving the other party updates on details of what you're going through in the course of the force majeure event. This would be the basis of the claim if and when the relevant force majeure exists. So once you convince the other party that an event is a force majeure event, what can you get? What kind of relief can you get? Time extension. This is, as you know, normal relief. That is granted from force majeure event. And alternatives. Change in law variation. Change in law is derived from the concept of an economic hardship principle, or the what's called principle of the changed circumstances. And you could argue that the various government orders or decrees they have come out since the COVID crisis that have disrupted your company operation. You could say that this is a change in law, giving your company entitlement to compensation for cost increase. But this just a movement to ask for compensation from change in law, but this is kind of hard to do. So my last slide deals with what to do for the future with the COVID-19. As you know, the force majeure event is something that occurs after the execution of a contract. You can claim from relief from non-performing of the contract, but this crisis is still with us. It's likely to continue for some time in the future. So what do you do when you enter into a new contract? Then, although this is after the although this is still prior to entering into a new contract, you still can put down into a force majeure clause, stating that this coronavirus 19 is still force majeure event, even though it has happened prior to execution of the given contract. The last item I'm going to discuss: risk allocation, renegotiation. I mean, this is it seems like everyone is suffering in this crisis. Just no winners or losers in this crisis. So once this is ended, I think it would be beneficial for the parties to get together, talk to each other. What are the consequences? And then try to renegotiate, try to allocate the risks that came out of the this crisis. Thank you for listening.
Thanks very much. I think we're going to John now. So John, could you please turn on your, excellent, thank you. You need to turn your microphone on as well, John, so we can see you.
Okay, hello, my name is John Rowe, and in this section, in this part of the session, I will deal with a very effective weapon that the Korean government has been able to use to combat the effects or impacts of COVID-19. Now, we all know that Korea was one of the first countries to be significantly impacted by COVID-19. We were hit very early and we were hit very hard. But in the face of that adversity, Korea, the Korean government and the Korean people were able to rise to the occasion and flatten the curve, so to speak. We've received high praise and recognition from the international community due to our immediate actions and to mitigate and prevent the effects of COVID-19. There were various actions taken, including securing development and supply of testing kits, controlling distribution of masks to prevent hoarding of essential medical supplies. The government also took steps to provide strict self-quarantine guidelines and policies. And they also educated on social distancing to the general public. They also exercised efficient and instant operation of disinfect teams. But most notably, they used a method called contact tracing, which allowed the Korean government and the health authorities to pinpoint the source of outbreak and to nip the pandemic or the outbreak in its bud. Contact tracing has arguably been the most effective weapon in combating COVID-19. Now, what we'll look at is what exactly is contact tracing and how it's implemented, whether it's actually legal, the legal sense, and the various guidelines that the government follows with respect to implementing contact tracing. So first off, what is contact tracing? Well, contact tracing is a method used by our government to track cases of COVID-19 in order to identify the source of infection for the purpose of isolating and treating such infection. In order to effectively carry out the contact tracing, the Korean health authorities have gained access to a well of source of public and private information without obtaining the consent of the information or data owner. These information include such sensitive information as credit card transaction data, mobile phone records, cellular geolocation data, and surveillance cameras. Now, if you've ever been to Seoul, there's everybody has a cell phone, so it kind of tracks where everybody is going. And then there's surveillance cameras all around the city. So if you're not careful, you're leaving a trace of where you're going. Now, contact tracing allows the government to use all that information, to gather that information without obtaining a warrant or without obtaining the consent of the information owner. The result of this is a detailed hour-by-hour, minute-by-minute reconstruction of the infected or potentially infected person's whereabouts in the days and hours and minutes, even minutes leading up to the infection. Now, how is contact tracing implemented? There's two main functions or elements of contact tracing. First off is the information collection aspect of it, and then what you do. The second step is what you do with the information that's collected, how you disseminate it, how you use it. With respect to the information collection aspect of contact tracing, upon discovery of a confirmed case of COVID-19, the health authorities conduct an epidemiological survey to determine the point of infection and possible close contacts. And then what they do is they conduct an interview with the subject. And then after that interview, based on that interview, they use all sorts of material, information, and data that's available to them. Again, including credit card transaction data, mobile phone records, cellular geolocation data, and surveillance cameras. They can get this information from private business owners as well and employers. So authorities are also allowed to extract surveillance footage, credit card histories, and all these information, again, without warrant or without consent from the information owner. After they've gathered all that information, what they do is, as a result of all that information collection and their epidemiological survey, they source out, they pinpoint the source of infection, and then they eliminate or they quarantine or disinfect the point of infection. So again, they use that information and they send out disinfectant teams, people, health authority personnel in hazmat suits will appear with disinfecting equipment and very quickly and efficiently nip the endemic or pandemic in its bud. So after they use that information to pinpoint, and what they also do is they also use that information to alert the general public of an infection or a public infection. If you're ever in a crowded area in Seoul, maybe a cafe or restaurant a mall, sometimes you can see the mobile phone alerts of a lot of people simultaneously going off. Usually that's the medical health authorities alerting the people in that location that there's been an outbreak. So the government uses that information and they disseminate whatever information that's needed to alert the general public. Now, the government also disseminates this information, but also the individual districts also maintain an archive of information that the general public can look up, and they also disclose, and they also have in their possession such information as the age, gender, ethnicity of a confirmed case, as well as the exact location that person has been in. So that's basically how contact tracing is implemented. Now, a lot of my foreign friends ask, number one, how is this contact tracing even legal? I mentioned again, I stressed again, this allows the government to collect sensitive information, personal information, without warrant or consent. Korea is a democratic society. It's not a totalitarian society. So how is this even possible? In fact, Korea actually has a very strict Personal Information Protection Act. This imposes strict compliance requirements on private entities, public entities that collect information. Most notably, it specifically requires that these organizations or entities obtain the prior consent of the information holder before collecting and using said information. That's the general rule. But with a rule, there's always an exception. The Personal Information Act provides for an exception to this rule, and so does the Infectious Disease Control and Prevention Act, the IDCPA. They've carved out an exception that allows for the government to collect these information without the consent or without warrant for certain public interest purposes, such as most notably for COVID-19, public health risk. So again, even the exceptions to the general law, General Privacy or Personal Information Act, that's also divided into the right to collect and the right to disseminate. Now, government agencies can collect and use data without consent for public interest purposes. Again, if there's a public health and safety matter at issue. The Personal Information Act specifically carves out an exception for that. The IDCPA grants the Minister of Health with extensive legal authority to collect private data without a warrant from patients. And then it furthermore allows the Korea KCDC to require medical institutions, pharmacies, corporations, organizations, and individuals to provide information concerning patients and persons feared to be affected. Now, this allows authorities, again, to extract surveillance footage, credit card histories, and cellular geolocation data of patients without a warrant. The right to disseminate function or exception, again, it allows, the IDCPA allows the public's right to know and requires the Minister of Health to promptly disclose information to the public about movement paths, transportation means, and contacts of patients of the infectious disease. So it basically allows the Korean CDC or the Korean health authorities to invoke the right to know to disseminate needed information so that the general public can get to safety with respect to COVID-19. Okay. So wherever there's a law, again, Korea is very quick to implement laws and make statutes very, very efficiently and very immediately to respond to various different situations. COVID-19 is also the same. We've carved out these exceptions in the Personal Information Act and the IDCPA to allow the government a great amount of discretion in collecting information and disseminating information. But with these immediate and large kind of discretion, there's always backlash, and Korea's statutes and regulations and exceptions weren't an exception to that either. I mean, during the early stages of contact tracing, the private information of some patients, including the names of their employees, occupation, and identities, were leaked to the public. And this sparked a controversy over invasion of privacy. And again, Korea, showing great flexibility, countered this, and the KCDC authored new guidelines to counter this on March 2020. Now, under these guidelines, authorities are allowed to disclose information on the destinations patients visit, as well as how they traveled, whether they traveled by bus or train. But they also put guidelines as to detailed information. So they put preventive measures or restrictions on the KCDC to expose or disclose detailed information that could identify the patient, like addresses and the company that they actually work for. So it's a work in progress, and even the guidelines, even with that, the guidelines still allow the disclosure of such private information when a patient may have infected large numbers of colleagues at work. And the guidelines also require the regional governments to limit their information disclosure to affected routes and places that actually carry the risk of virus infection. So it's a work in progress, and Korea, to our credit, we've been very flexible and very responsive with respect. If there's ever a problem, the Korean government has never been, they've never been hesitant on going back and trying to fix these problems. And I see more guidelines to come in the near future. Okay, so again, contact tracing has been a very efficient means that the Korean government used to combat COVID-19. Again, Korea, I think part of the reason why it's been so efficient is that, again, Korea has the infrastructure, and a lot of the people in Korea they have mobile phones, and they have a digital trace that the Korean government can very easily gain access to. I mentioned again that the various surveillance cameras you see all around it in Seoul. It helps. There's kind of a big brother aspect to it, but it also helps deter crime, and in this situation, helps to combat such public health risks as COVID-19. I often joke to my friends, my foreign friends, that if you're ever a Lord of the Rings fan, it's kind of like Korea. The information available to the Korean government, it's like the eye of Sauron. The evil eye sees all. Only in this case, the Korean government is using the eye for good. It's not using it for evil. It's not using it to conquer Middle Earth. It's actually using it in a good way to combat COVID-19. Again, Korea. This is a legal method that's born out of necessity and the exceptions that the Korean government carved out because of the necessity to give the Korean government this broad authority to access information, use that information for the public health or public good, and also disseminate whatever information that they've gained to alert the general public to take immediate action. I'd like to stress out that the contact tracing, that's what the government can do. So it doesn't necessarily mean if you own a private business, you could do the same thing that the government does. So I get some questions from clients that whether they can share information with respect to their employees and potentially infected employees. I always advise, in those cases, I always advise them to contact the Korean health authorities, the Korean CDC, once they're notified and once it's in their hands, they can kind of give you the guidelines you need to kind of navigate through whatever situation or adversity you're in. Okay, thank you very much, and I'll leave the reins to Jane.
Thanks, John. Hi, everyone. So I'll be talking about staff reductions and layoffs, which is, I guess, quite topical in the COVID-19 context. Looking at the impact of COVID-19 on the Korean labor market, as you can see from the first chart, this shows the unemployment rates from January 2020 through to May 2020. The second chart shows the number of new COVID-19 cases that we saw between January and June 2020. And as you can see, it peaked quite high in February through to sort of early March, and is now sort of tapering off. When you compare these two charts, you can see that despite holding fairly steady during the height of the COVID-19 crisis, unemployment rates have recently hit a new high. And interestingly, it's inverse to the number of new COVID cases that we are seeing. And in May, in particular, the unemployment rate in Korea jumped to 4.5 from 3.8 in the previous month. And this was the highest jobless rate that we saw in Korea since January 2010. So despite efforts to contain the impact of COVID-19 on the labor market, the worst fears about layoffs have already started to become a reality. You may have already seen in the news, but Hyundai, as early as February, had to shut 2 of its factories down in Ulsan because of supply chain issues, and also one of their employees had contracted the virus. In April, EasterJet announced that it was reported that EasterJet would be laying off about 750 employees, which constituted about 45% of their workforce. Korean Air had 387 of its foreign pilots go on unpaid leave for 3 months, and they've also have cut the pay of their entire staff, and also have started to make them go on leave in rotation. And Doosan, heavy industries and construction, which recently escaped a financial crunch by receiving a state loan of about 1 trillion won, it looks like they may also have to reduce its workforce reportedly. So it looks like layoffs, restructuring of workforce is going to become more of a reality in Korea. And while many continue to make their efforts to retain their staff, big companies are starting to say that they are now being pushed to the edge. And a survey conducted by the Korea Economic Research Institute saw that 32.5% of big companies had said that they will have no other choice but to let go of their employees if the COVID-19 crisis continues for another 6 months. 67.5% said that they would struggle to hold on to their employees for more than 6 months. 9.2% said that they wouldn't be able to hold out would only be able to hold out for 4 to 6 months. And a total of 23.3% said that they wouldn't be able to last for 4 months. So, but will the COVID-19 be sufficient reason for laying off under Korean law? And what issues would need to be considered when an employer looks to lay off its employees? And under the Labour Standards Act, which is the main employment legislation in Korea, the requirements for layoff are as follows. There needs to be an urgent managerial necessity. Every effort by the employer must be made to avoid dismissal. Any layoff needs to be reasonable and based on fair criteria. There must be good faith consultation with the labor union or the employees, and there must be not less than 50 days notice. So what constitutes urgent managerial necessity under the law? Well, it must be objectively recognized as being reasonable in order to cope with future crises in advance. The court has held that conservative estimations of the company's expected sales volume will likely be recognized as long as it's based on reasonable and objective assumptions. Layoffs will also need to be based on overall management of the business and not just on certain business sectors and divisions. Whether a decline in short-term revenue and profits due to COVID-19 will constitute justifiable reason for layoffs is probably unlikely. But if there is a reasonable expectation that a company that was suffering a continuous decrease in sales or net loss will severely suffer further due to the COVID-19, and that such downturn will continue even after the COVID-19 passes, then layoffs may be deemed to be justified. So assuming you've established that there's an urgent managerial necessity, then you need to make sure that you've made every effort to avoid dismissal. And the Korean law provides various other measures that the employer should and is expected to take before coming to laying off their workforce. And I've listed some of them here. There's of course reduction of work hours. This requires employee consent and an amendment to the rule of employment. Reduction of salary, again, you need to obtain consent of the majority of the trade union or employees. But recent case law has also held that even if you have obtained consent of the majority of the trade union and employees, you will also need to obtain individual approval depending on the contents of the individual employment contracts. Use of holidays, employers may encourage their employees, but not force the employees to take their annual leave. And the timing of taking the annual leave is usually up to the employee, but under certain circumstances, the employer might be able to control that. With the COVID-19, there has been a rise in working remotely. How do we do that? I think there's a lot of flexibility around this, but if there's a policy within the company, you follow that rule. If the employment contract sets out where the working location needs to be, then you may need to obtain consent of the employee. This also invites tracking issues and work compensation issues that you probably need to take into consideration. You may also think about transferring your workforce. And employees usually have a significant discretion in this, but you will need to, particularly in the COVID-19 context, balance that out with the employer's legal obligation to make sure that the working environment is safe for the employee. And then there's some practical measures to be looked into, particularly following the Ministry of Employment and Labour guidelines, which focus particularly on creating a safe workplace for the employee. And then, of course, the government support, which I'm sure you all are aware of, and the subsidies that are being provided. And then we come to inviting voluntary resignations, which, as mentioned above, EasterJet has been doing. Of course, you need to offer an exit package for that. And then another option would be to suspend the business. And a few things to note on that is an employee who suspends his business for reasons that's attributable to him would need to pay a cessation allowance to the employee, and that would be about 70%, up to 70% of average wages. And there were a couple of other criteria listed above. Reasonable and fair criteria would also need to be satisfied. And a typical example of what is not reasonable or fair is layoff based on gender. And consultation is a process that's required because you need to discuss the methods of how to avoid termination with your employees and your labor union, and the standards for selecting employees for termination. So whether the long-term effects of the COVID-19 will have any impact on the actual law that sort of controls and governs layoffs, in the near future, it seems probably unlikely, but we will have to see. But for the time being, an employer considering layoffs in the wake of the COVID-19 should plan ahead and obtain legal advice early on, because the legal requirements for layoffs are extremely strict and very fact-based, and there are very difficult hurdles laid out by the law. And if a company is found to have been in violation of the law when it laid off its employees, it will have to reinstate the employees with back pay and interest. And other than the other sort of measures mentioned above, of course, consider practically using the government subsidies to balance out the costs of reducing work hours and providing paid leave. And at the moment, large companies can receive 2/3 of the shutdown allowances paid, and small, medium enterprises in all industry sectors can receive 90% of the shutdown allowances paid. And importantly, don't assume that you can lay employees off simply due to COVID-19. It's only in exceptional cases, for example, complete closure of an organization's business, that a company is presumed to have urgent business necessity. And that's a very difficult standard to meet. And just as an example, in Korea, so far, things like bankruptcy, M&A business transfers implemented to prevent severe business deterioration, liquidation, closing down a department or a line or a business division has become unavoidable. These have been cases where layoffs have been justified. So just a few things to consider going forward. Thank you.
Thank you very much. Sorry, I know we are due to hear from Jenny and Jinhee in a second, but I just wanted to say that we do have questions coming in from the audience, both on the Q&A and in the private chat to panelists. So I don't know how you want to deal with that. Should we address the questions now, or would you prefer to proceed with, well, Jenny and Jinhee, would you prefer to give your section first? How do you want to do it? I mean, there's some interesting questions here we might want to consider.
Maybe we can wrap up the presentation quickly and take Q&A.
That's great. Yeah, we'll come back to it. Yeah.
That way, then we can take questions all across different topics.
Perfect. Yep. So to those of you
who don't mind,
we'll get to that in a second.
All right, Jane, if you don't mind unsharing your screen so we can. Okay, take it up. I'll share this with you.
Okay, thank you, everyone. You're still tuned in. My session today will cover the effects of COVID-19 on the debt financing market in Korea. I'll start with talking a little bit about what we've been seeing in the market, go over some of the government responses, and then share some thoughts with you about what to expect in the days ahead. So market status and development. So what's happening in debt financing in Korea? Right now, and it's still early, it appears that we're managing. At Chipyeong, we haven't seen any defaults yet due to COVID, although we're working with lenders who are working with their borrowers to manage the situation, whether it's to issue waivers or give time extensions or assess whether there's amendments to financial covenants necessary. And interestingly, despite the gloomy forecast earlier this year, the market statistics show, just like we've been seeing, that there's not yet a marked rise in loan defaults or distressed debt, or a significant drop in the bank's overall performance. And these are according to numbers from the the banking authority. So for Q1, for example, loan defaults and the trend with non-performing loans both are at below 1% of all loans, and have shown actually negligible to no increase since the end of 2019, which was pre-COVID. And as for the bank's overall performance, actually it's up. So yeah, so what to make of these market statistics that seem actually a little bit better than what we initially thought might be happening. First, I think we need to take the statistics with a bit of a grain of salt. We're now already towards the end of the second quarter, and these numbers are from the first quarter. Also, there's always just a natural lag in effects between the financial economy and the real economy. And it may be too that we're still in a bit of a prolonged calm due to the many government stimulus efforts. So really, it's just very early and uncertainty abounds. But what's certain, what we've been seeing is that there is an economic slowdown in progress. We've got sharp decline in our exports, and we're an export-driven economy. And we've experienced declines in domestic consumption and corporate investment, brought about by social distancing measures and the business and factory shutdowns. And ensuing from that, labor instability, as Jane had already shared with you. And the other variables or stressors that are affecting us right now are the continuing US-China trade tensions and possibility of a second wave of infections. So not unsurprisingly, the government has had to revise its growth forecast for 2020. And as you can see, it's at 0.1% now, which is basically no growth. And that's the worst since the 1998 Asian financial crisis. And still, it's a little bit more optimistic than Bank of Korea, IMF, or OECD, who are all predicting negative growth for Korea. So one possible reason for the government's cautious optimism with respect to growth may be because they've just been really aggressively pushing out relief measures. As you can see, there's just the measures that are geared towards the small businesses, and medium-sized enterprises. There's some 17 different support programs already. And yeah, it's quite far-reaching. The total, I think, now is at 270 trillion Korean won, which is a little less than 270 billion US dollars, and about 14% of GDP has all been earmarked towards these programs. We've listed here for you the major ones for the businesses, but there's also another 90 trillion won set aside for personal welfare subsidies as well. And one particular support program, though, that stands out a bit from the rest is the Key Industry Stabilization Fund. And this is actually a discretionary relief fund that will be run out of the Korea Development Bank for large corporations. So this is, at first glance, a bit anomalistic because our presidential administration is known to be quite anti-conglomerate, but one key condition to relief that will be given to companies that qualify is that they will be required to keep 90% of their workforce in place for at least 6 months upon receiving support. So in that sense, it really is in line with the government's focus, which is really to protect jobs. And well, so that's where we are right now. And it's really anyone's guess because it's so early as to what we can expect in the days ahead. But I thought I'd share a few of my guesses. I think going forward, we're going to see best practices become the norm. I think for many of us, we all know what we should be doing. and may not have been doing things as proactively before the pandemic. But what the pandemic has shown us is really that these best practices are necessary. So just, closer attention and better analysis of borrowers and their businesses, their industry sectors, attention to compliance and financial monitoring and transparency issues, all of that probably most people or most businesses have stepped up because of the pandemic, but really should just, in the name of crisis management, but really should just be a part of day-to-day management. And I think that that's going to be happening more. Also greater attention to documentation of EODs and MAE, and financial covenants, because now we have a real life context, right, for what could go awry and what sort of procedures we may want to have documented so that we can deal with these kind of situations. I think we'll also see lenders finding that they need to reassess their business models and maybe their risk appetites so that they can have more flexibility and in borrowers that they are willing to lend to. Closely aligned with this, we'll be seeing with the government also needing to, probably amend financial regulations. They already have, but to allow the flexibility for lenders to lend, and for borrowers too. They're going to need to expand the scope of financing sources. I mean, once their debt capacity is maxed out, they're going to have to look for new sources, like probably existing shareholders or other types of equity financing. And I think what will be really interesting will be the expanding role and effects of the fourth industrial revolution. So Korea is already one of the most advanced data economies. And what we've seen in the pandemic is that online service and retail sector has just really been thriving despite other business failures. And the government has also committed itself to really supporting innovation and businesses in the ICT and high-tech sector. So it'll just be really interesting how all of this pans out in terms of financing and where the investments will go as these industries further try to develop their businesses. And finally, the government debt and spending right now. It's been great that the government has really pushed out all these stimulus efforts, but I think the concern that raises is that in the short term it's good, but how long can the government coffers sustain this kind of support? And so it would be really nice to see, and hope we will see, the government working with businesses to see what can be done for just industrial revival, labor reforms, and legislative reforms. And I'd like to end with a quote I read recently in the Foreign Affairs magazine, which states, "In truth, what is killing us is not connection, it is connection without cooperation." And that actually was a statement relating to foreign policy in the midst of the coronavirus. But I think it applies equally to what we're seeing here in the Korean economy. And I believe that cooperation is going to be essential to getting out of this, whether it's the the lenders and borrowers working together, or business and the government, or government and society. And so far we've been showing that cooperation, and I hope it continues. Thank you.
So quickly moving on to how Corona affected dispute resolution in Korea. This is Jenny Kim. I'm going to be shorter than even Jenny. How COVID-19 affected litigation substantively. It's too early to tell. So we don't have hard and fast statistics to explain what's going on substantively. But what we do know, that there are at least 2 lawsuits that have been filed in Korea for spreading corona, or causing virus, because the businesses have to disinfect their premises and quarantine themselves. There's that lawsuit by city of Daegu. Daegu is a city that was hardest hit by corona. 70% of deaths in Korea occurred in Daegu. So City of Daegu is suing Sincheonji Church, which is the group of church that was the source of a super spreader. Jeju Island is also suing, or is going to sue, a tourist that carried COVID-19, but was touring Jeju while she was taking painkillers, it seems like. Other than that, the KFTC investigated and fined 4 mask vendors who sold masks online for violating the e-commerce law, canceling orders and then jacking up the price, getting gouging the consumers. So we don't have at this time a large-scale dispute related to COVID because of contract disputes or failure to perform force majeure. We don't have that, but we are receiving a surge of inquiries from our clients about what might happen because of their business delays and interferences and inability to perform. We have also, and we know that there are lots of complaints from consumers that relate to cancellation of hotels, airline tickets, events like marriage ceremonies and stuff like that. So we do expect that next year there will be many disputes relating to COVID. It just has not occurred just yet. And we also expect to see a lot of trade disputes because of COVID. How did COVID affect procedurally? The picture you see here is a rarity because you don't often see what the courtroom in session looks like. You are allowed to attend. It is, the Korea law is that every trial should be open to public, but you're not allowed to take pictures or even report. So it is a rare occasion that you get to see the inside. This was on Law Times on March 4, 2020. This is Seoul High Court, where they held a hearing by video. So the people who were shown in video are counsel for each side. This was echoed in judges' chambers, where the judge is actually discussing procedural matters with the counsel of the 2 parties. Is this the first time? Not really. The Korean procedure allows you to use video virtual hearing when necessary, and there have been at least 10 video hearings in 2019. But definitely, because of the COVID situation, the courts have resorted to virtual hearing more this year. So by May, there were more than 30 cases. Courts have slowed down. They are holding hearings at a greater interval than before, which is usually 4 to 6 weeks. Korean courts have not shut down like courts in other countries have been. With other industries, Korean courts have been in operation for the vast majority of the first half of 2020. But courtrooms are still limiting audience. They're taking less audience to be sitting in and observing the trials. Now, what is going on in the arbitration sector? The arbitration community is actively promoting arbitration and virtual hearing amidst the COVID situation. And we see this happening not only in Korea, but in other jurisdictions as well. In fact, the arbitral institution around the globe, the DIS, ICSID, SEAC, what have you, including KCAB, have issued the so-called COVID-19 joint statement, which is just what Jenny said. This is collaborating to promote arbitration and make sure that there is still a justice system amid this situation where you can't really convene, courts cannot convene to conduct hearings. So, and also KCAB is actively promoting that. Recently in April, KCAB hosted the first ever, I believe, mock arbitral hearing, and to show how, I think it was Zoom, how hearings could be held regardless of the in-person inability to meet in person. There's also the Seoul Protocol, which is very handy if you're considering virtual hearing in arbitration. So, is virtual hearing the new normal in dispute resolution in Korea and elsewhere? We don't know. It's still a history in the making, we believe. But there are some concerns we still have with virtual hearings, such as due process concerns. Is virtual hearing adequate in terms of due process protection? It really depends on jurisdiction by jurisdiction, depending on the governing law. But definitely there's the concern about the tribunal's impaired assessment. If there's any impairment that at the tribunal, in tribunal's assessment of the witness's credibility, which is key to determining facts of certain disputes. Are you going to allow real-time, how are you going to allow real-time consultation between counsel and the parties? Is there equal access to technology between the claimant and respondents? So all of these issues are not yet sorted out. And based on my experience trying to do virtual hearings, there's some artificial feel to it. So it's not like in courtroom situations. So yes, there are difficulties to overcome, but we definitely think that there is new normal for dispute resolution. And I do believe if the courts are less prone to resort to virtual hearing, then I think the arbitral institutions may play a bigger role in the days forward. So this wraps up Ji Pyong's presentation on a variety of issues, and I return the floor back to you, James.
Excellent, thank you very much. I guess what I would like to do now is to bring JM into the discussion, if I may, and then we can address some of the questions that have been asked. So JM, I'll give you a brief introduction, if I may, and correct me if I've got any details wrong, but JM is, I would say, a rising star of the in-house profession in Korea, but I guess that's not really accurate because he's already the GC of an international company. He's also already had a very sort of distinguished career. He's worked as an adjunct professor at a prominent Korean university, Yuha Women's University. I apologize if I'm pronouncing that incorrectly. He has been the director of international affairs at the Seoul Bar Association. He's been a partner at a Korean firm where he specialized in litigation related to government agencies, and he is now GC of Delivery Hero, where he works on a range of matters from public policy to M&A to employee and labour issues to compliance and risk management, so all very relevant to the topics we've been discussing today. And Delivery Hero, I'm sure you're all aware, is one of the leading online food retailers and food marketplaces. It's a German company, but it's active in Asia Pacific, Latin America, the Middle East, has over 500,000 restaurants to its name, and I'm sure you've all been using it very much during lockdown. So, I mean, I have some questions for JM. JM has asked some questions of the Ji Pyong partners, but how do you want to do this? Jinhee, do you want to interview JM? Do you want to ask him some questions, or shall I?
Leave it to you. We'll follow your directions.
Excellent. Okay. Well, look, JM, I'll start by asking you a question, if I may, because one of, I guess, the obvious impacts of COVID-19 on business has been the change it's necessitated, I guess, in employment practices, who can work, where they can work from, how they can work, and we've heard some of this from the presentation today. But I guess as GC of, I suppose, a non-traditional business, one that relies on a mobile workforce, you're in a slightly different position. So what issues have you encountered with regards to the workforce as GC at Delivery Hero?
Yeah, anyway, I'm very glad to meet you, and personally, it's very first time for me on webinar to speak, so I'm very excited and a little bit nervous. Yes, and I want to introduce myself a little bit more. I'm just a Korean lawyer, but now working in the global company, so GC in the subsidiary of the global company, so I can experience many multicultural climate and etc. But now my business is our domestic areas, so I'll still work in the company. And then I want to answer your question. Yes, our business is online marketplace and on mobile platforms. So maybe people think we work in the mobile technology, but actually we meet more than traditional company, I think, because we make two new business. We should develop new thought, new categories. So every day we meet together and have sometimes eat together and have tea and coffee and sometimes even drinking together in the company. So, but because of the pandemic, it's very difficult to meet together. So ideation is very difficult for us. because we have many ideation and the discussion always, and especially we meet other parts employees very often, sales, marketing, operation, tech, information securities, but it's very difficult to meet together. So yes, it's most difficult for me. So we are so talkative person usually. IT employees very talkative, but we can't meet very often and very closely. So we are hoping this situation getting soon past. We hope.
Okay, excellent. And what about the relationship with vendors and suppliers at the company? I mean, has that changed significantly? Have you had to do a lot of work there as general counsel?
Yes, we have some problem. We are O2O business, not just online business, but O2O business. So we have some relation with the riders and the restaurants. We have more than 100,000 restaurants. That means our employee visit some restaurant.
Just in Korea, you have 100,000 in Korea alone.
Yes.
Yeah, okay. That's a lot.
Yeah. So our sales employees visit the restaurant and have some negotiation or discussion. After then, have some contracts. But because of the social distance, it's very difficult to sales promotion. Is most big problem. Then maybe it's the commonplace among the O2O business, I think. And we are just marketplace, so our profit is related to the profit or business of our vendors. So our vendors have some difficulty and sometimes at stake, and some our vendors are bankruptcy. Then our business, the fundamental of our business, we also at stake. So now we are going to support our vendors, riders, etc. Yeah, stakeholders. Yeah.
Interesting. Something Hoon said earlier, I believe it was Hoon, he said that there are no winners or losers in a pandemic, but perhaps there are opportunities. I mean, one of the things, I guess, for a non-traditional company like Delivery Hero is that you maybe have an advantage when it comes to dealing with a pandemic. I mean, is that your perception of it? Do you think you have an advantage? Relative to traditional businesses, of course.
Yeah, thank you. A crisis is always an opportunity to some people crisis, but to some people crisis. So honestly, actually, that this crisis gave us some opportunity, but frankly, we don't make profits yet. Maybe it's very similar with many online marketplaces, but people think we make so much money. So many vendors or governments or press demands us so much and so much things. So it's very difficult for us. But one good thing is I joined Delivery Hero 1.5 years ago, last year, January. But at that time, I have so many things to do, but it's very difficult to find a person. Especially lawyers are usually so conservative, so they prefer law firm or the traditional companies. So when I posted JD to the job marketplace, but just a few person apply for us. But nowadays, many candidates apply for us, so it's very good thing for me.
Oh, that's interesting.
And now I'm still finding a lawyer and employees. So if you are interested in them, please contact me.
Great. I'm sure many inquiries, so we have a recruitment drive from JM here. Look, JM, I also wanted to ask as GC, obviously the COVID pandemic's hit every company. I'm sure you've been inundated with requests from various business teams. I mean, has that taught you anything about crisis management and risk planning in general? I mean, has this situation been a learning experience for you?
Yes, our company, I am responsible of not only legal matters, but also GRC matters. GRC means governance, risk management, compliance. So actually, I suffer from many daily problems. I confront every day. I confront new cases I never expected. So I was so busy every day. But in that day, I also should spend my time and resources to the fundamental things. Fundamental things, corporate governance and risk framework is more important. So we should invest that kind of things. And I think that kind of things we in-house council can't deal with by ourselves. So because we are always busy and they have to is weak and long-term the project. So I think in-house council should get some consultation from external law firm and that kind of things. The one more thing is we confront of many situations every day, and we should solve very quickly. We don't have so much time to wait to get approved from many people. So I always try to delegate and entrust my employees, because our business is during 24 hours. So sometimes in the midnight when I was asleep, but some case occur, then my colleague can decide by his or her own authority and own decision. So I try to give interest to my employees always. And maybe my CEO is also the same with me.
Yes, yeah, excellent, Chris. Look, I know you had some questions for the panelists that you've sent through during the chat. So perhaps this is a good opportunity to bring the JPyong lawyers back on, and perhaps they'll have questions for you as well. Can you remain with us for a few minutes while we address these?
Yes, it was very impressive, and thank you so much to JPyong lawyers, because always, many in-house counsels, I am always busy, so I have no time to study. But today I done a lot today, so it's very good for me.
Thank you very much. Look, JM, sorry, perhaps you could remain with us for a few minutes while we address your questions, because I think you had a question for Bernard or Bernard and Hoon.
Okay, I want some question. So, the remote consultation to patients is very interesting for me, because associations of physicians are against, but consumers are already can experience that kind of things and like it. So, but if then the remote consultation will be discriminalized or legalized, then, but I think individual physicians have some difficulty to deal with that kind of things. So then, like us, some platform companies will launching service for virtual consultation. How do you think, and is it likely to be legalized? And I want to know your expectation in the future, because if it will be legalized, then the very new business market will be open. So
Bernard and Hoon, perhaps one of you can answer that. So I guess, yeah, firstly, are remote consultations likely to be legalized? And if they are, will we see platform companies offering this service?
Right. Well, thank you for that question. I think it's a difficult question to answer, but for the time being, the service is okay to be provided in Korea. I think it'll really depend on the experience that and the data that the government collects. The government has already published survey results, as well as the number of cases and the amount of services that were provided as part of that 260,000 cases. So they are keeping a close watch on it, and I think this pandemic is expected to continue for the time being, and I think more and more data will be collected. And I think it really depends on the results and the experience of not only the physicians but the patients, as well as how the government feels about the potential risk that could come from a physician seeing his or her patient remotely. And if it's legalized, I'm sure platform companies would love it. I think it'll be a nice service. And also, I might add that the other advanced countries are experimenting with telemedicine currently, and there is some good experience coming out of it. So we'll just have to see.
Okay, very good. Yeah, good idea. And can I ask one more question to Jinhee? A quick question.
Yeah.
Yeah. You told that the mask vendors fined by government. So actually, many mask vendors contact me personally because it's difficult to find masks. Then the vendors told me that they can provide masks to our company, but I was so nervous, so I rejected. But my question is, then the company that buy masks or sanitary products against the law also can be punished, or just the vendor who provide masks will be punished? I wonder.
Frankly, I don't think that's my area of expertise. Maybe it's something that maybe Bernard can answer. Frankly, the fines that were made were for violation of the e-commerce law. So it wasn't really relating to the manufacturing regulations, or even there are special regulations that were just set up for the purpose of being able to supply masks to everybody. So maybe Bernard, you can help me on that. If you violate the production regulations, can you be penalized? I'm sure, I think they would be. There are many investigation and raids that we see in the news, we have seen in the news. So I don't know if you have instances.
Right, I think it's the Ministry of Health and Welfare that has jurisdiction over this. And I think they're, they have required all these manufacturers to supply and account for all of the masks that they're supplying, not only internally, but also from an export perspective. I have not heard of any enforcement activities in this area, but the law is certainly there, and I suspect that it could you could see enforcement in the area. But as you know, the supply of masks just a few months ago was a big problem, but with the COVID cases coming down in Korea, there has been plenty of masks to be supplied and distributed. So I think that's how I view the issue.
Okay. Anyway, we should comply the law, I think. Thank you.
We have several more questions from the audience that have come in. I don't know if you have time to address some of these. JM, there's also a couple of questions for you, so I hope you can remain with us. But I'll ask, first of all, and this is an open question to all JPyong partners. Someone has asked, can JPyong lawyers assist businesses with writing business continuity plans for organizations in Korea? Is that something you're able to assist with?
Oh, most definitely, yes.
Absolutely.
Okay, great. They get a nice soft question to start with. Okay, but is that something you're doing a lot of? I mean, are people coming to you asking for business continuity plans to be drafted on their behalf?
To me?
So are you seeing a big increase in those sort of inquiries? I mean, are more clients approaching you during this time asking for help with drafting business continuity?
Oh, yes. Yes.
Well, we do have increasing inquiries and consultation requests for our crisis management team, which is a newly set up to deal with this pandemic, not just pandemic, but as companies experience unexpected, unanticipated crises and situations. Yes, we do. And a lot of the work that we do in connection with crisis management is proposing and exploring various business continuity options, restructuring plans, debt financing. It is all part of that, the bigger commercial context of crisis management, risk management. So yes, I don't know if that answers the question.
I think it does.
It also relates to the.
If it doesn't, then perhaps the person who asked it was an anonymous attendee, can submit a follow-up, and we'll deal with it in a few moments. Okay.
That's very good.
Another question that was asked, and I guess this is one to the JPyong lawyers rather than JM, but what temporary measures are available for businesses that are looking to restructure? I mean, are there any kind of interim relief measures or temporary measures available under Korean law?
Then can I ask one more question?
Sure, yeah, then we'll come back to that. Yes, please.
Okay, I want to ask John. Yes, because of pandemic, when the pandemic situation, also government authorities can collect very sensitive personal information. So actually, Seoul City and other city governments collect the formation of the Itaewon Club.
Yeah.
And I think hackers try to attack so many data and the companies. So we are also be attacked always. So we have huge money and resources to protect our data. Then I think I'm wondering government are aware of that kind of attack or hacker or prepared. So how do you think, and if an extent, then what's the result? And the individual person can sue the government also. How do you think? Litigation?
Okay, so basically, to answer your first question, Korea actually has an organization called the Korean Internet Security Agency, KISA. It's a subsidiary, it's an affiliated agency of the Ministry of Science and Technology. The KISA provides they provide guidelines, they provide assistance as to protection of data. They provide guidelines to businesses as to how to protect sensitive data, and information, personal information included. Not just personal information, but also you have corporate information. You have a lot of workers working from home these days. So they're working from their computers, and that's kind of, a lot of the times, that's out of the purview of the company or the corporation's internet security jurisdiction. So not only for personal information storage, the KISA provides assistance and guidelines. I think they're a step ahead with respect to the concerns that you raised. They understand that we're dealing with a situation, Korea, Korean private entities and the public entities that have suffered, have been attacked by hackers in the past. So they're very keen on that. So that's one method that they're using. Now, with respect to whether a person can sue the government if the government went too far in disclosing certain information, I think there hasn't been a substantive case as of yet. But I think if there's a case where the government steps over its boundaries, again, I'd be remiss if I didn't mention that there's in the guidelines, there's a standard where the government or the private entity that's doing the government's bidding, when they're disclosing the information of a private citizen, the standard here is always the minimum amount of information that's necessary to protect the general public around that infected person. So you can't. So a big no-no would be disclosing the name, the address of the person. Usually it's dealt with using that standard. I guess if there's a situation where the government goes over that standard, then we'll be looking at civil cases moving forward. But again, that's the standard that's used. Another question that I'm sorry if I'm stepping ahead of anybody's, but another question that I get asked a lot is if there's an outbreak, and if there's an infected person in your workforce, how much information can you disclose and who can you disclose it to? Basically, the rule is if there's an outbreak in your workforce, you can disclose to your workforce, the personnel that's working near the infected person. You can most definitely inform them of the personal information of the person that's infected, because you need to kind of, do your own investigation as to the point of outbreak. So that's the standard. There are exceptions where you're allowed to share personal information, such as names, but that's only limited to situations where you're trying to protect your own workforce.
Thank you. Very good tip I think. Very good.
We have a question about investigations. I'm sure there are a number of partners who can answer this. So obviously, we all know the number and severity of actions taken by government bodies through investigation is growing. I mean, how has COVID-19 changed practices of government agencies when it comes to investigating companies? Has there been a big change?
Well, we have heard news that rates have been reduced considerably in February and March when Korea was hardest hit with COVID. But afterwards, I do believe business has returned to as usual, and there are investigations, except that I think on-site investigations may be fewer, and the investigations are also relying on the virtual methods through email communications and telephone consultations and so forth. Trials, criminal trials, likewise affected as civil trials. Because criminal trials are also public, open to public, and there being less availability for audiences to participate, and there being larger intervals between hearings, it is being delayed, just as any other processes in Korea. That's about, maybe that answers the investigation. Somebody also asked about cybersecurity. If you're having virtual, if I may go on and answer that as I
please do.
have the podium here. Cybersecurity is an issue. We all know that Zoom is not the safest method of virtual meeting, which we are using. So it's not something that I don't think that parties to a very private, confidential arbitration should be resorting to. I do understand that there are online platforms that are being developed specific to institutions. Korean courts use their own program for virtual hearings. I do believe that arbitral institutions should be looking into this because of the security concerns, but it is, as of now, an open question. We do need to address them.
Excellent. Look, I think in the interests of time, we should probably wrap up here. I'm sure there are many more questions. If anyone does have a follow-up question or wants to know anything further, perhaps they can contact the lawyers at JPyong. I'm sure you'll be, presumably, Jinhee, you'll be happy if people email you with their questions following this. Excellent, great. Look, well, thank you very much from the Legal 500, and thanks, of course, to all the partners at JPyong. It's been a great pleasure. So thanks to Bernard, Hoon, John, Jane, Jenny, Jinhee, and of course to Jayan of Delivery Hero. Great thanks from us. As I said at the start, a video of this webinar will be posted on our website later. If anyone wants to watch it again, you can do that. So thank you very much for attending.
Thank you, James.
Thank you very much.
Thank you.
Thanks.
Have a nice day.
Right, thank you.